Hey, right, everyone. Good evening. Hope you're doing all right. Usual stuff. I just got to put some stuff in the chat and whatnot. So yeah, usual two bits, guys. Firstly, please do not share personal data. That includes asking questions about your own situation. You can obviously ask questions about your own situation, but make it as a what if question, as in what if someone was in this situation, what would be the answer? You'll get the same answer, but you don't have to put your personal data up there. And secondly, this is not legal advice. We're going to do our best here to be useful, but obviously we're not in a position to give like competent legal advice. And I'm not, yeah, neither nor me nor Shannon are qualified to anyway. So, um, cool. Right, I think I've done everything. Yeah, cool. So we've got two questions that have come in through the week, which we'll tackle first. So if you're watching live, I suggest you don't hang about until you ask your question because because we might finish within like 3 minutes or something. There's a bit of news I just thought I'd share. Let me get the thing up and running. So, if you've been watching the live stream for a long time, you might remember that back at the end of last year, there was an LG SCO case that was upheld in Leicester City, and it was basically family in B&B for more than 6 weeks, and Leicester City said, "Yeah, we're not gonna comply with the recommendations," which yeah is rather like I don't know disconcerting really. So because obviously if councils stop following the LGSCO, then it kind of just weakens the law even more. Um, but I guess reassuringly, the LGSCO are not leaving it. So basically, they've gone back to Leicester and said, "You've still got these outstanding actions here," and the third one being the council must consider this report and confirm within 3 months the action it has taken or proposes to take. If the council officers or cabinet are minded to recommend refusal of our recommendations, this report must be considered at full council. So that, and I've just looked, it's a Labour controlled council. So there is actually like a single party in control rather than some councils where it's all a mishmash and it's like there's no overall control. So in one sense, the Labour councillors would have to formally say that they're not going to follow the recommendations. Obviously, Leicester don't want to follow the recommendations because I would expect there's a whole load of other households in the same situation, which they're probably also owing money to. So yeah, it's kind of probably a fairly high stakes case for them. But yeah, so that was that. For those who aren't kind of subscribed to the LGO newsletter, I suggest you do so because every Thursday lunchtime you'll get a bunch of cases. I've actually not looked through, haven't had time to look through yet today in terms of what's come up, but usually there's one or two cases which are interesting. So yeah, that's the gossip from me. I guess I'll probably also mention, I think I said last week, I've set the training program basically up until Christmas. So there's like we've got two main courses. So Introduction to Homelessness Law and Demonstrating Priority Need, which is the new one. And basically I'm doing that for the first time a week tomorrow. And then the next date is pretty much filled up already. So if you want to basically have a look at Eventbrite, just search for homelessness best practice on Eventbrite, you'll see the upcoming dates. Um, but yeah, I think that's all I've got from me. Any news from you guys at all? Any interesting stuff? Obviously, quite a lot happening in the news right now, but not particularly relevant to homelessness, other than the fact there's no homelessness minister right now, and there's no housing minister as far as I know, unless Angela Rayner got replaced by someone else that wasn't the deputy PM. Maybe she did. I don't know. But anyway, yeah.
I've
Well,
got a tiny bit of news.
yeah, go
Just
for it.
a little, There's a little light-hearted thing that I've just been working on a case involving a local authority assessing whether somebody was vulnerable and in priority need. And they did an initial decision based only on a questionnaire without asking any questions of the doctor. And then after I sent the medical stuff in, the reviewing officer sent them on to Now Medical, and there's a one sentence instruction which reads, "Can we do a Now Medical on this case for priority need and self-contained accommodation?" And that's it. But I like the idea of doing a Now Medical, which I think most people in the trade means produce
Sounds
something of
dirty.
the, and they did do a Now Medical. Now Medical did the usual. The person has been treated at a low level with a referral to talking therapy and intermittent use of medication. It's just
Is have Now Medical actually taken in the correct information into account? Have they even looked at the file, or have they just kind of gone on some very shallow stuff from what the council's told them?
we got a print out of the medical records. But the interesting thing was, by the time they were instructed, the reviewing officer forgot overlooked a report. I'd got a report from the GP saying this, I'm very worried about this person. She's got significant ongoing medical conditions and she's in a very fragile condition. Homelessness is going to exacerbate her condition. So they didn't pass that on to our medical. So I'm hoping that that'll
Yeah, I
work.
mean that'll do it.
I've just sent off the instructions to the barrister on that one, so hopefully we can JR them early next week.
Yeah, cool. Let us know
First,
how that goes. I mean, so now, yeah, I was chatting to someone we both know today about Now Medical, and lamenting about how, yeah, how they don't take the right information into account. Let's put it like that. Um, doing a Now Medical. All right, yeah, cool. Thanks, Will. Oh, Karis just nipped off. Anything from you till Shannon this week? All quiet. Cool. Well, let's get into the question. How you right, Western Goddess? You right, life forms? Nice to have you here tonight, guys. Um, so let's get the bit of Word document up and running. So yeah, so these are the two questions that are coming for the week. As I am saying quite regularly now, if you want to guarantee getting your question answered and also don't want to worry about a character limit, then putting it through the week is a good way of doing it. So you do that just by going on any video on the YouTube channel and just asking your question there. Again, it needs to be anonymized, but yeah, just that way it means we get a notification. Someone was a bit late tonight, but I managed to squeeze it in. So yeah, question one for this week. So brief description, any advice would be appreciated. The landlord is selling the property. And by the way, this isn't anonymous, but there's no other questions to go on yet. So I'm going to just do this one first. We have a Section 21 notice and now a possession order stating we must leave by the 15th of September, I guess. During the Section 21 process, my ex and I split up, so I'm now single male, and she's receiving separate help. Her advisor is assisting with her interim accommodation on or before the 15th. My guess is there are kids involved. That would be my guess of why that's been so straightforward to get interim accommodation offered. My advisor says I need to wait for the bailiffs. The problem is I'm not even on the tenancy agreement, and the landlord believes they will get the property on the 15th. I suffer from mental health issues and have no idea what I should do now. So there's an aspect to this question which I don't know the answer to. Hey, you right, Michael? But if I kind of start us off, so I mean, in a sense, I'm assuming this is a guy. Don't know that for sure. Oh yeah, no, it is. Yeah, single male. Yeah. So this guy needs to make a homes application separately. There's a video on the channel called "The Best Way to Make Homes Application." Have a look at that. It's long and drawn out, but if you want to get it right, you want to get it right first time. The most, the kind of the biggest headache cases are where things aren't sort of, they don't get off on the right foot, and then it just kind of leads to a whole bunch of confusion and yeah, all that sort of stuff. So yeah, check out the video. I think it's like an hour long or something like that, but it's methodical, and you want to be methodical in this process. So make homeless application. You have a legal right to wait until the bailiff stage of the eviction. So you do have a legal right to stay. And if you're not, and so what we're going to see here is that this is probably going to come down to a question of priority need, because if there is reason to believe that you're in priority need or you might be in priority need, Section 108 would state that once the Section 21 is expired, which it already has, I'm guessing at this stage, so we're already kind of a fair way down the eviction process, assuming you've got recourse to public funds, or you might do, then the council's duty to provide interim accommodation would kick in basically now. But as I say, priority need is, as Will's just alluded to in his bit of news about kind of Now Medical and all that sort of stuff. Priority need through vulnerability is probably the single biggest area or cause of injustice within this whole system. There are other causes as well, obviously, because although the threshold for vulnerability is not very high at all, yeah, basically there needs to be something noticeable about you which puts you at noticeably more harm than a healthy and robust person would be if homeless. So if you've got existing mental health issues, that's probably going to tick the box. But unfortunately, it's just an area where councils can can fuddle people with lots of jargon and just make a perverse decision. And it's no quick way to kind of deal with it unless you've got a solicitor on your side. So I think that's what it's going to come down to. Trying to work out, yeah, I'm trying to work out though in terms of the bit I'm not quite clear on here is if this person's not even on the tenancy agreement, I don't know I don't know if they do have a right to remain up until the bailiff comes. Karis, you got a bit of wisdom on this one.
Yeah,
Sorry, you're
sorry.
unmuted, so I picked on you. Yeah.
I heard you say it. So so if the tenancy agreement is a contract and it's between the landlord and the person that's renting, the tenant, the person that's renting the property, if your name's not on there, you don't have a right to be there. So you don't have a right to stay. So if your partner gets housed, if she's getting help and she gets housed before the 15th and that possession hearings, you could be classed as a trespasser and you could be required to leave almost immediately because you actually have no right to be there. So that is quite a predicament for you to be in there staying.
Yes, well, so I guess that would mean that even it's the kind of argument about priority need is going to be brought forward to now, or like the possession date, I guess. So yeah, there's quite a few videos on the channel which try and explain what vulnerability is. It is a genuinely kind of complicated idea. Most housing officers, I think, don't really understand it very well, but then I don't think many lawyers do either, because there are lots of moving parts to it, which kind of came from lots of different cases. But yeah, but basically what you want to focus on is the argument to say that because of this, because of this guy's mental health issues that, he's already dealing with, if he was to become homeless, those mental health issues are likely to get worse. And that's I can say that, has probably been true even without knowing anything about him or what his diagnoses might be, because I can't think of a mental health issue which doesn't get worse if you're homeless. What health issue, what mental health issue out there is not going to be made worse by higher levels of anxiety and so on. So I would say anyone with existing mental health issues, there's already a good argument that you're in priority needs. And legally, I'd argue there would almost certainly be reasons to believe that you might be in priority need and therefore hit that interim accommodation threshold. But I would say if you can, lawyer up basically, or like find someone with capacity. And I don't think Carousel will have capacity right now. But I think that would be what I'd be doing. I guess you'd also be kind of like belt embracing it and actually looking at local services. I mean, the council should tell you like what local services you might be able to access, so like night shelters, supported accommodation, and so on. But sadly, there's a very high level, very high number of people who genuinely are in priority need through vulnerability, and councils just shrug them off. And because it's very difficult to fight the argument anyway, but let alone when you're homeless, that means that councils get away a lot of the time with issuing perverse not in priority need decisions. So yeah, yeah, yeah. There'll probably be more to say if we knew what the mental health diagnosis would be. But as I say, I can't think. I mean, reasonably familiar with the variety of mental health diagnoses you can get, and then there ain't any that aren't affected by stress and anxiety and stuff like that. So yeah, anything you guys want to add to this at all?
I mean,
Sorry, Chris, you go on.
I was just going to say about leaving. If you can if you have a good relationship with the landlord or depending on the reasons for him taking you to court, him wanting the property, you could talk to him and say, could you stay for a little bit and grant extra time, and could you stay or could you have a little short-term tenancy while you're looking for somewhere to stay? But that would be depending on if you can help your relationship with the landlord. But otherwise it's talking to the local authority.
Yeah.
What I was going to say was, in addition to lawyering up, if you can, try and talk to your GP, because if you haven't seen the GP for a while, the GP may not be up to date with how you are. And if your mental health has been deteriorating as a result of these issues, and it sounds like it may be, then the GP can be ready to write a report. And if the council contact them and say, how's he doing? Then the GP won't be saying, I don't know, I haven't seen him for 3 months. Because I appreciate a lot of people with mental health problems may not go and see a GP as often as they might do, but it's worth doing that and just talking about how you're feeling. Because I got a very useful report from a GP this week, which could make all the difference to a priority need case.
Cool. Thanks, Will. Thanks, everyone. I'm sorry, I'm just multitasking, trying to work out the next question. So, yeah, I think we've covered the bases there on that question. I'm just going to bring in this next question from the live chat. So, nope, come on, copy and paste function. I'm still not sure if that's got it either. There is a reason why it looks like I can't use a computer. It's because I'm going to blame YouTube because it doesn't let me select certain bits of text. Yeah, let's try this. I think I've got it this time. Yeah, cool. So, well, that's the first part. Here's the third part, but if I just put the word problems in there, that gets us part of the second part. So, oh, there's a bit more. Okay, so person's got second stage complaint with the council. Also waiting on the outcome of section 204 appeal due to unsuitable accommodation and physical health problems. Would it be best for the person to wait for a section 204 appeal decision from the county court and then decide if a person should raise a complaint to the LGSCO? The person's goal is to receive an acknowledgement from the council that things went wrong as well as maximum compensation possible. Could you explain the best way to deal with the complaint process for a person to get a max compensation? So, there's an argument to say wait until the section 204 resolves, because that will then probably, if it turns out the accommodation wasn't, well, let me put that the way. If the appeal is unsuccessful and effectively the council's decision that it is suitable is upheld by the courts, then even if the council followed the wrong process in assessing suitability, then basically it seems that you're unlikely to get any compensation. So there was a case, I think Will mentioned it either here or on his live stream a little while ago, where there was basically a decision where the council hadn't undergone the right process for, they hadn't evidenced the fact they can correctly consider suitability, but the property was suitable, and so therefore it was taken that although they hadn't actually done the right things, their decision, they kind of that was okay. I mean, it was a bit of a dirty decision in my opinion, but anyway. So I think, potentially if the 204 appeal is not successful, then that would have probably a very negative impact on the compensation claim. However, if it is successful, then that certainly bolsters the position that the council didn't do their job properly, because they didn't correctly assess that what suitable accommodation needed to be. And so that's my answer to the first part of the question. In terms of maximizing compensation, have a look. So Google LGO. In fact, I'll get it up on my computer so you can see it. Hold on. So LGO guidance on remedies. It used to be a nice tidy PDF. It's not anymore, unfortunately. It's kind of like spread over various pages on their website. But anyway, so if I just get that up so you can see what I'm looking at. So this is, as I say, I just typed in that phrase and this is what I got. Guidance and remedies updated this year. And you want to look at part 2, because part 2 sets out basically how the council should do a proper apology, which some of them struggle to do. Kind of what principles, and then there should be some more stuff. So quantifiable financial impact. You've got things like that would be like if you lost property or something like that. But there's other bits and pieces in there. But there should be non-quantitative. Where is it? Sure, there's like non-quantifiable or qualitative remedies as well. See if I can find it. No. Symbolic payments. This is what we want to look at. So within this, you've got these kind of elements. So distress, harm or the risk of harm, time and trouble. So time and trouble, I would say you're probably always going to be looking at a payment for that, but it's only going to be like 100 or 200 quid. And then distress is probably the most common next one, which is, as it says here, significant anxiety, frustration, upset, or pain. And I'm sure that means physical pain or emotional pain there, actually. So again, this could be a bit higher. It does give some figures. So in fact, so we've got like kind of a bit more of an expansion of it here. So distress, uncertainty, raised expectations, lost opportunity, and it should say a payment here. So normally recommend a remedy payment for distress of up to 500 quid. So it's not a lot. Harm or risk of harm. This could come into play. So if you've got somebody who has a disability and they've been put in unsuitable accommodation and that's kind of led to more physical pain or something like that because of the having to get up and down stairs when you're not really able to, then as it says here, a payment of up to £1,000. I have managed to get more than that on certain occasions when it's like ridiculously bad stuff. Time and trouble. How much does it say here? Oh, is that up to 500 for this as well? And then non-direct injustice. Now, it does use the word outrage somewhere for this. Can't find it right now. But yeah, I mean, basically the answer is have a look at that document because you've got, yeah, sorry, let's go back to the start for a second. You've got the kind of general kind of principles, but then if you go back to chapter index, you've then got bits specific to housing and homelessness. So on this one, like, so basically where you haven't been provided, oh God, if it was a PDF, this is what I don't like about it, because um, if it was a PDF, I could search for terms. So here we go. So where a complainant has been deprived of suitable accommodation during what would have been inevitably having a stressful period in life, our recommendation for financial redress is likely to be in the range of 150 to 350 pounds per month. So if you haven't been given suitable accommodation for 10 months, let's say, then I would ask for a payment of £3,500 because that's at the upper limit. No reason not to. If there are particularly, things which kind of you can kind of go further than that. If you feel there's stuff which is exceptional, particularly severe, then kind of increase it further. But that's the sort of payment you'd be looking at. And again, kind of they've got more detail on it. So just to give you an idea, uh, weirdly, you would get more money as a family being kept in a B&B for more than 6 weeks than you would be if you were rough sleeping, which I think is a real oversight of the LGO recommendation on kind of remedies, but it is what it is. So, yeah, as I say, because I think for unsuitable B&B placements, you're looking at weekly payments of between £100 and £200. So, quick maths, £800 a month, as opposed to 350. Now, I don't know, as I said, I don't know why that there is that kind of discrepancy there, but there is. So yeah, that's hopefully enough to kind of get you going on that. So have a look through that document in detail, spend some time in it, and when you're asking, when you kind of you're kind of going to the next stage, set out what you think's relevant and how much money you think you should get for each element of it. So yeah, any of you guys want to add anything to that? No, okay, cool. So next question. So yeah, someone's like, well, we'll stick it in the chat. We'll stick it in the thing. So hold on. So no, hold on. Try that again. So you had a video post on the channel titled "How long does it take to get housed?" About 8 months ago. I wanted to ask how accurate are those waiting times today compared to 8 months ago for councils across England. Now, I doubt they've changed that much in that 8 months, although I'm sure some councils will have changed a bit. But I think, as I said in that video, there's various caveats to those figures anyway. So it's kind of a guidance, and if nothing else, it's supposed to show that there's a big change, big difference around waiting times around the country. But you need to treat those figures with a pinch of salt anyway. I'll probably do the same exercise next year and then kind of probably do some kind of average figure. But unless there's been like a huge splurge of house building in a particular area and therefore the waiting times would come down, I don't really see any other reason to think they've changed that much in that time period. I mean, they're now coming up to being a year old because I did the FOIs like last autumn. So that I think the reason I did the whole exercise was I think they are useful, but they're still averages. There's still still limitations to the quality of the data. I'm having to take the word of the people who respond, the officers who actually got the figures, because somehow some local authority officers don't seem to care that much about accuracy, so they'll just give you any old figures and kind of how you to know otherwise. So yeah, I think that's I mean, I'd say that would be my answer. So watch the video again to just pay attention to those caveats anyway. But I think realistically, they probably haven't changed that much. That would be my answer to that. So next question, another one about compensation, I think. So what if a temporary accommodation tenant wants to claim compensation for despair? I'm going to take that to mean disrepair, but correct me if I'm wrong on that. Because the legal aid lawyer advised that they can't claim under legal aid. Is this true? So yeah, I mean, so legal aid funded lawyers, as I understand it, now Will and Karis might correct me, but they're only funded for very limited things. So they're not funded to help you make complaints. That's kind of it's not their job basically. I mean, there isn't anyone else unfortunately who can do it instead, so you have to do it on your own. So again, as previously the answer I gave for question 2, it'll be down to you. There's a there's a video on on the YouTube channel called "The Best Way to Make a Complaint." I'm not very imaginative with the video titles, but it is what it is. And again, you know, that kind of methodically goes through what you'd want to do to put together a compensation claim for disrepair. The good news is that often it's fairly clear cut, and actually relatively high compensation payments tend to arise from disrepair issues in TA. So if let me just bring up something else as well, just to kind of give you an idea that a good resource you might want to have a look at. So I'm basically sharing this every week because I think it's a great resource. I may be biased, I don't know, but if we bring up the LGSEO database, so this is on Will's website. At some point I'll try and get up on my website as well, but don't know when that'll be. But if we search for disrepair, I can spell it. There we go. So you basically got a bunch of, these are all like individual decisions. You can see there's a lot of them, 16 in this one. So, and then basically what you do is I don't know, just pick one at random. Let's pick up Milton Keynes here. So if we just grab that code there, we take to the LGO decision page, put the reference number in there. We then get the actual decision. And there, you know, these decisions are worth reading in detail. If it was me, I'd read through all of them that had related to disrepair, because there's a lot of stuff, a lot of detail in here. So yeah, here, analysis and findings. The council knew of the disrepair at Miss T's temporary accommodation from at least December 2023. It should have inspected the property then, at least. It could, yeah. So it kind of explains what the failures were. And then the council should address this by way of a payment of £250 per month of delay. And I assume that it was 8 months if the overall figure was £2,000. Can't remember what it was now. Yeah, £2,000. So it would have been 8 months. So have a look through that database for other disrepair cases and just see how it works out, because they can be very instructive in terms of like you working out what chance you have of being successful as well. So how you right, Martin? So just to reiterate, guys, so this isn't a place to get kind of personal advice. So there's someone just puts a disclosed personal data, so I'm just going to remove it. I'm not being horrible, or I'm not trying to be horrible, but yeah. So all we can do on this live stream is kind of ask or answer what if questions. That's it. We're not able to give out individual advice, and I'm pretty sure all of us are at capacity anyway. So this is the best we can do, unfortunately. And there's just a follow-up question here, which I'm not quite sure what the context is, but we'll give it a go. So a person wants to find out what is a protocol letter. So my guess here is that this is for certain types of compensation claims, you have to kind of do protocol letters beforehand. So my experience is very limited. Again, Will and Karis can probably do a lot better than me and Shannon can on this one. But certainly when the data breach claim, which I've talked about a little bit on this channel, that me and Will were able to get earlier this year for someone, there needed to be a particular protocol sent to the council before kind of, you can kind of get a barrister involved and start threatening to go to court proper. So that is my guess of what this is about. Karis, you got any better idea than I have on that one?
So the protocol letter, so there's before court or conversation, there's a protocol you have to follow. So for example, disrepair, you'll send in that you've raised complaints and you've put the landlord on notice. And then there's a procedure you have to follow in terms of going to court, and legal aid doesn't cover compensation claims, no. So it would just be a guide of how you have to proceed in making any claims to do the work or for compensation. So it's called pre-action, which is because court usually for any litigation, court should be a last resort. They try and get people to solve the issue themselves. So the pre-action or protocol is designed for it not to go to court, but because sometimes, especially with tenants and landlords, there's quite a conflict and there's quite a big issue to try and settle between yourselves. So it's very hard for the landlord and tenant to come to agreement before court. Sometimes it will work, but most of the time, no, it doesn't. So that's where it's trying to just ease that burden of the courts and not have so many applicants into court. So you try and go through this procedure first, and then you're going to the court. So it's just kind of a procedure you have to follow. And there's templates out there that you can, especially for the disrepair. It's on the disrepair guidance. So there are loads of templates out there you can type in. It's even on the Citizens Advice website. We'll get a template there.
Cool. Thanks, Chris. Cool. So I think, yeah, again, I'm multitasking here. So sorry if I, yeah, think I'm staying on track. Next question. I think I can actually help out with this one. So check if we're still on the same screen. So yeah, there's a bit more to it. Because when I did this, I did pick up on some good council, so to speak, to actually apply to. That were actually relatively close to London. So here it is. So might you guys know off the top of your head of any commuter towns councils for a one-bed or bungalow outside the green belt with good public transport networks into and out of London with a short waiting time for single individual applicant looking to move out of London, dealing with domestic abuse, any commuter towns? So if I just bring up the map of these figures, and I might just bring up the Excel sheet as well at some point, but basically we zoom, oh, don't do that. Zoom in. No, come on. Yep. So basically the color code is like green is good, yeah. And what you see here is that East Hertfordshire, Decorum, probably just those two, they have very quick waiting times for homeless applicants owed domain duty, which if you're fleeing domestic abuse or affected by domestic abuse, you would almost certainly be owed domain duty. And I would, I don't know why that they are so low. Maybe the cynic in me thinks that they're just really kind of good at gatekeeping, so they kind of have very low numbers actually applying to them. So I don't know that for sure. I'm not kind of guessing there, but yeah, those two are kind of ones I noticed. I know with Decorum they have a ridiculously high. They have a 10-year residency requirement for Part 6 applicants, which would not apply to you if you're fleeing domestic abuse. But yeah, those ones I just picked out. If you give me a minute, I'll be able to get the Excel sheet up as well, which is on a website. Hold on a sec. I think it is. I'm looking at Shannon because Shannon would put it there. Yeah, cool. Hold on. So if you go to hbpconsultancy.co.uk and then you go to resources and then you go to somewhere in here. I'll find it in a minute. I'll come back to that. Bear with me on that one. But yeah, so that would be oh yeah, new haircut today, by the way, guys. I missed a bit, but I think I've got it now. Yeah. So yeah, I think that would be my answer. That would be so. Just check out those councils. When you are affected by domestic abuse, in effect, you can kind of apply to any council in the country, and they're going to owe you the main duty. There are a couple of caveats with that, but councils can't refer you back to an area where you're at risk. So yeah, basically, that's kind of that'd be very unusual for a council to be able to refer you somewhere else. So yeah, that's my answer on that one. Do you guys want to add anything to that at all, Shannon?
I've got nothing to add. Just quickly, it's not on the website because you wanted to brand it first. Just thinking about it. So
Yeah,
apologies.
cool. That's right. So I have got the. Let me just I'll hang around at the end because I'll put the Excel sheet up on the screen. We can have a look together. But let's keep going through these questions. Check I haven't missed anything. So, next question 7. In the eligibility process, if you're told you're not eligible only for not having a disability, then being told to look in private housing, what could have been done instead? If you're told you're not eligible. So eligibility is a really confusing word within housing and homelessness law because it means different things at different points. In narrow terms, eligibility is about essentially whether you have recourse to public funds or not. And that's the word they use within the homes application process, but it's an everyday word as well. So I'm not quite sure what they might be saying here. They might be saying that, people without a disability don't get social housing. I don't know why they'd say that, but I guess some councils they might they might de facto say that even if it's not technically true. Yeah, I can't. I might need a bit more detail about the questionnaire to make sense of it. So I don't know, does anyone else here have a better idea than I do about what that might be talking about?
Sorry, would that mean the eligibility process for accepting a homeless application or looking at inquiries, would that be priority need? I would take that as, so not having a disability, you're not eligible for priority need, therefore not eligible. 'Cause you don't,
Maybe, yeah.
I think
Yeah,
they're
I don't.
referring to priority need.
I mean, I think. I
They're
mean,
just encompassing all under the eligibility process.
yeah. Okay. I mean, so basically, like, yeah, there are plenty of people without disabilities who would be in priority need through vulnerability. So it's not. It's like, I mean, councils try and have it both ways. You know, they'll say, "Oh, yeah, you do have a disability, but that doesn't make you in priority need," and they'll also say it the other way around. But yeah, that's not. It's not. I mean, it's relevant in the sense that it's an indicator, and someone with a disability may well be in priority need specifically because of the nature of their disability. They probably are, in fact. Um, yeah, so there's a clarification that the eligibility to be qualified to be housed. But again, so I'm not trying to be difficult here at all. Uh, because that can still mean various different things when you're applying to housing. Because I'll give you a very quick overview of I don't know, maybe try and help you kind of narrow down what it is you're asking. There's basically two processes that look similar, but they're actually entirely separate. That that councils basically run if you're applying to them for housing. And so you can apply for social housing and you don't even need to be homeless. And there will be various eligibility criteria to qualify for. It's called Part 6, the Part 6 route, basically. Um, so that, yeah, they will use that word eligibility, and that will also encompass things like disability as well. But there's also the homeless application process, which is the Part 7 process, which again, eligibility is a word which you can, you know, use technically and use kind of in layman's terms as well, and it means different things at different parts of it. So the eligibility to be qualified to be housed could could relate to both Part 6 and Part 7. So I guess I mean my first question that should clear it up a little bit is this person homeless? But even then, there's a problem where councils don't actually use the correct process for people depending whether they're homeless or not. So it sounds like I'm being really awkward and difficult there. I'm not trying to be. It's just a really confusing area. So again, if that person could maybe just provide a little bit more background about the, you know, um, this was more lenient to the homeless application. So more lenient, more relevant to the homeless application. Sorry. Yeah. So in the homeless application, technically eligibility is about whether you've got recourse to public funds. Uh, Having a disability or not won't affect that at all. But as Kara says, you know, it's much more likely that disabilities will come into play with priority need. But again, it's not the same thing. So it's not like an automatic thing. If you have a disability, you're in priority need. It doesn't work like that. It did very briefly, but that's another story. Yeah. So just the person asking about kind of areas to apply to, though the map is from the same figures that I did 8 months ago, so it's the same quality of data. But again, I can't imagine it's changed. I mean, changed that much. So green meant less than 50 days. So I can't imagine it's, you know, kind of gone to, you know, 50 years or something since then. So I think it's an indicator. So okay, just to say as well, this I respect this. This person's pushing it in terms of like anonymizing the question. We'll go with it. So if you could try a bit harder, guys, to what if it up, then that'd be great. But this will do. So what if I have chronic anxiety, already contacted my local council and have been placed under prevention duty, but told when I become homeless I won't get help? They can't tell you that really, because I doubt very much they carried out the priority need assessment properly yet. I don't know. I'm trying to think if you would do it. I guess there might be times when you would carry out an assessment of priority need during prevention duty. But as we've said already multiple times, vulnerability, you'd be basically trying to get priority need through vulnerability. And this is an area where councils, first of all, often the housing officers don't even know what the law is. They will quote different cases. They don't have a foggiest idea what those cases actually say. They'll have template letters which they're using, which again don't actually help them make the right decision anyway. So chronic anxiety, again, anxiety is something which certainly could render you vulnerable just because of the anxiety, you know, just on that one thing alone. But it just depends, you know, chronic just means long term. It doesn't necessarily mean, it doesn't kind of say how severe it would be. But again, you know, if you, I mean, there's a really helpful case called Thomas v. Lambeth, when in effect, Miss Thomas's presentation was she had depression, anxiety, and some suicidal ideation, and that in that case, that was enough in her circumstances to warrant a priority need decision. But it's always based on the individual circumstances. So what, you know, what a good housing officer would be doing is saying to the treating doctor, you know, professionals involved, what does this person, yeah, what diagnosis did this person have, and what's going to happen to those conditions if they were to become homeless? That should be the only question they really are. Well, one of the main questions they're asking the doctor. But yeah, as we say, like, it's just something which it's incredibly easy for a bad housing officer just to issue a perverse decision. So again, the answer is lawyer up and basically be prepared to challenge it. As Will said earlier, go back to your GP now, so your GP's got an up-to-date kind of idea of how you're doing. Update them with any information. But I would put quite a lot of money on the fact that this housing officer has not actually carried out enough inquiries to make that decision, or even, as I say, there is a really weird bit about priority need and prevention duty, but I doubt very much that's kicked in, if I'm honest. I think that the sensible money would be on the fact the housing officer simply hasn't done the right assessment, they haven't asked for the right information, and they haven't actually used that information properly. So yeah, I think that would be my answer. Anything you guys want to add on that one? As I say, like, it's, yeah, unfortunately, yeah, as a professional working in it, it's the bit that makes you the angriest, because it's the bit where the most injustice is done. It's almost like the fact is that the more vulnerable you are, the easier it is to just fob you off and tell you to go away somewhere, and not follow the law, basically. So be prepared for a fight, I think, is the answer. Unfortunately, not that that's going to do your anxiety much good, but I think that's the reality. You want to get a good advocate on your side to help you win the argument, really. Bear with me a sec. That's a good question here. I don't know if I know the answer off the top of my head. We might have to go digging around in the code of guidance. How long can someone be in the prevention duty stage? Landlord stating they're selling Section 21 and HL homeless application made February, still in prevention duty. Council state prevention until court papers received. This is right. So no. Well, technically it could be. So this comes back to the question of, in that eviction process, at what point do you become homeless rather than threatened with homelessness? So threatened with homelessness is where you're likely to become homeless within the next 56 days. Whereas if you're actually homeless, even if you might have a roof over your head, you might have a legal right to occupy your property, but that doesn't mean to say that you are not homeless. And in the code of guidance says that in most cases, most people will be homeless once the Section 21 expires. Having said that, there are still situations when potentially the council would be at liberty to keep you in prevention duty, because although it generally says, you know, prevention duty, well, in fact, in an eviction process, it just basically says the prevention duty keeps going until the relief duty kicks in, which is the point when that person becomes legally homeless. So the answer is, it's probably not right, but we don't have enough information here to know for sure. One of the most relevant things here is, does the council think they can persuade the landlord to keep you with financial incentives potentially? And if the answer to that is yeah, maybe, then you are less likely to be homeless once the Section 21 expires. It's likely to be later in the court process. So, but basically, the further down the eviction process you get, the more and more likely it is you're homeless. So basically, the code of guidance certainly says that, you know, council shouldn't be telling people to wait until the bailiff comes. And again, if we actually go back to yeah, rather than kind of go into a lot of detail on this again, if we go back into the LGO decision database, sorry, it's taken a while here. Here we go. And if we go to this and we search for the term bailiff, we get a selection of LGSCO decisions, which basically, you know, they're all upheld really. So they basically not only uphold the complaint and the people are getting a bit of compensation for it, but also it kind of explains what the law is. So if we look at this one for Thames side, that looks like a good one. If we go back to here, go back to the search page, put that code in here. We get the Thames side one here. So I'm not going to read it all through, obviously, but it kind of explains what the law is. what point do you become homeless? So these paragraphs here, 6.35, all around that area of the Code of Guidance are really useful. They basically set out what the law is. And I think in this one, essentially part of it was the fact the council didn't properly assess it anyway. So yeah, she got £400. I think it was she. Yeah, it was. She get £400 compensation. So it's not a lot, but it's better than nothing. So yeah, have a look at that database and see if you can find some stuff on there. Just search for the term bailiff, as I say, and you'll get a bunch of relevant decisions pop up. So next question, how are we doing for time? Right, we might have to call time on. Yeah, so I'm going to say no more questions from this point. So as in from this point in the chat, so no more questions from, I can't spell questions from here. So if you put questions in after that, I've just written that out, we'll have to roll them until next week, as in you'll have to come back next week and ask them again. So this question here relates back to the question 7. More relevant to the homeless applications. The person was about to become homeless and eviction letter was provided by family carers. Have I got that one right? Yeah, so I guess the question is, did they mention priority needs? I think that, yeah, as Kara said earlier, did they mention that phrase priority needs? Otherwise eligibility would generally mean whether or not you have recourse to public funds. And if you don't have recourse to public funds, then there's not a lot the council have to do at all. Contrary to the Daily Mail, what they might say. Okay, so yeah, hold on. There is a bit. This maybe can help us out here. So yeah. So in the end, the individual was told, as you don't have a disability, we cannot continue your homeless application. No further action can be taken towards providing that. So, right. So even if so that does sound like it's about priority needs. However, just because you're not, even if you're genuinely not in priority needs, the council still have to discharge the relief duty, which is not a huge amount of help, but better than nothing. And so, but you can chat. So that sounds to me like they've made a decision that you're not in priority needs, and you can challenge that. And again, yeah, the argument is, yeah, the fact that you don't have a disability, that isn't the kind of the deciding factor. You need to look at what kind of issues you're facing. Again, it's difficult to kind of give an overarching kind of thing, but generally, is there something about you which would differentiate you from a healthy and robust person, as the legislation calls it, that would kind of put you at noticeably more risk of harm than a healthy and robust person would be if homeless? That's kind of it in a nutshell. Difficult to explain. So yeah, if you're confused by that, you're not alone. But yeah, I think that's it. So I'd be looking at, I think the answer here would be, did they just say that verbally? If they did, then that's clearly BS. Did they put it in a letter? In which case, did the letter explain what further duties they had? Did they explain how you challenged the decision? Those kind of questions is probably what I'd be going to next. Karis, you got anything on this one?
Yeah, you briefly touched on it, but you have a right to their decision in writing. So they should give you the decision that they've come to in writing. There should be a letter. And that will give you a chance to request a review. So which you can do.
Cool.
It's just like getting it in writing.
Yeah, cool. So there's a couple of questions. Yeah, there's a clarification of this one about section 21, which is helpful, but I'd still say go check out that LGSEO decision database and kind of read the detail for yourself, because there's a bit of nuance to it basically. But yeah, certainly, I guess all we can say here is that it sounds like the council may well be breaking the law there, but we can't say for sure on the information we've got. So yeah, just a question about, so the best way to get questions answered on this live stream is to ask the question in any comment section on any video on this channel. Make sure it's anonymized. I get a notification and I bring it in advance. So actually what we're going to just quickly do now is just dart back to the other question we had in advance, which also wasn't anonymized, which is why I've saved it till the end. And then we'll finally dive into that map and the figures around it, because there's a few questions kind of cropping up about that. So Question 10, if I place a bid on a 2-bed maisonette, 2 single bedrooms and a number 1, can I withdraw my bid if my household actually needs a 3-bed property, parents with 3 children? We're already overcrowded and don't want to face the same situation again. Would this be considered a valid reason for not to accept the offer? I think potentially it would be, but you want to have probably a conversation with the housing officer or a housing officer and just explain, look, you made the bid without kind of thinking it through or without realizing what was involved. Got hair in my mouth. I think I got it. But yes, I think what you don't want to do is reject it without basically okaying it with the housing officer's team. So yeah, so I think just contact them as quickly as you can, explain what's happened, and hopefully they're going to be reasonable. If they're not been reasonable, kind of go with the process. I don't quite know. I mean, the reason I'm not quite sure is the systems I'm used to dealing with, they wouldn't allow you to put a bid on an unsuitable property in the first place. I guess it depends on the age of the children here. So, for example, if one of the children are under 12 months, then they might say, yeah, technically that's not overcrowded yet, even though it will be in 12 months' time. And so they might just be difficult like that. So I think just have a sensible conversation if you can. Do you guys want to add anything to that? As I say, I've not kind of seen this thing because, as I say, I'm pretty sure in Bedford the system doesn't allow you to place a bid on a property which isn't the right size for you, with some caveats. But yeah, other than that, we'll leave that. So, okay. Very quick question, which I'll answer very quickly. So, is there a limit of the amount of councils an individual dealing with domestic abuse can make an application to? No, there's not. Legally, you can apply to loads of different councils simultaneously. If you don't believe me, let me just show you the code of guidance, just so you can see where it's coming from. However, pragmatically, I would say, oh, where's everything gone? It's shuffled my screen up. Hold on. Let's just do it a different way. So, and this is code of guidance. So I'm just Googling it now. Homelessness code of guidance. Let's just bring it up on the screen. So hold on. So if we go to 18 point whatever 9 or something, I can't remember. 18.7, 18.9, yeah. So in some cases, applicants may apply to more than one housing authority simultaneously, and housing authority should be alert. So it's when it says they may apply, it's not saying they're allowed to, just say they might do it. So you can always do it. But in my experience, you're much better off just applying to the one you want to live in, which you think is going to be the best chance. Because what happens when you apply to multiple councils, although it's illegal, they will just play hot potato with you and say it's the other council's job. And so you're actually making your job harder. You're making your life harder than you need to. So yeah, I think the answer would be try and work out from what the best evidence you can find, try and work out what council is going to be best for you and just apply to that one. That's my suggestion there. So let me get the full stats up from the from those figures. I've got to remember which folder I saved it in, so I can never remember this. Is it in resources? No. I did like kind of tidy this up the other day. It's not right. We're just gonna have to search for it. Hold on. Waiting times. And we need to get this one here should do it. So it's a hold on a sec, it's taking ages. But it is getting somewhere. Or is it? Yeah, it is. Okay, so let me just bring this up. So yeah, you have to pause it and whatever. So these are the caveats, because I say, like, this is the best information I could get. There are various reasons why it might not be very accurate. And then you've got, so bear in mind, some councils didn't provide any figures at all, or they only provided general figures. So you've got the list of councils here. And if we're looking, I think for this person, they're asking about a 1-bed. These are the number of days from the point at which the main duty has been accepted. So it's not the total number of days. It's basically going to start a couple of months down the line. And if I just kind of scroll down, you can kind of pause it and see what you want to look at. But if we look at, what was it? Decorum was one of them. Basset law is the lowest in the country, by the way, 6 days. That's in the Midlands somewhere. If we go to decorum, 55 days on average for a 1 bed. I probably went over some of them too quickly. Cheltenham, 63. Broxton, I don't know where that is, 77. Bolsover, Bolton, Blackburn, all of Northwest. They're kind of, well, Bolsover's in the Nottingham area, I think. So yeah, you can kind of get an idea of these figures. I'm just going to sort of scroll through so you can kind of, I mean, it might be easier just to look at the video actually on from 8 months ago, but these are the figures. East Hertfordshire 59, which I think was another one they're looking at. Field, I think that's Northwest again. Hartlepool, yeah. So you'll notice quite a lot of them are a long way from London. Ipswich, 21 apparently. 21 days. That's not too far from London. So yeah, if you look at the video on the channel, you've kind of got, I basically post the figures at the bottom of the video as it goes through. But yeah, I think, yeah, you get the idea really. So that, yeah, you notice that if nothing else, there's a massive difference. So you've got Kensington and Chelsea, 2,095, Rugby, 70 days. So yeah, treat these figures with a pinch of salt for sure. But you know, so don't yeah, don't come and sue me if it turns out that Decorum have actually got a really long waiting time. But yeah, that's the best we can do. So there are some we've got 3 minutes. There's some very quick questions that have come up there, which are fairly straightforward to answer. So what is the definition of overcrowding? There are at least 2 different definitions of overcrowding in the law. However, neither of them equate to homelessness automatically. So you might hit that definition of overcrowding according to the space standard or the room standard, but unless you can show it's not reasonable to continue to occupy the accommodation because of it, you're not legally homeless. So yeah, in terms of bungalows, no, not able to give that amount of detail. I didn't think to ask for that sort of breakdown, unfortunately. But yeah, so yeah, the map is for 2-bed waiting times, but bearing in mind they're fairly similar. So if you go onto the video on the channel, look down the bottom, you've got the full figures. You've got 1 bed, 2 beds, sometimes for bed sits as well. So yeah, so that's it for this week, guys. Thanks for all your questions. If you found it useful, please do give it a like. If you haven't subscribed yet, please do, because you get notifications of new videos. I'm going to do some new videos at some point soon. It's been a long summer, but I'm getting my head back in the game a little bit, so I've got a bit of time, hopefully next week, to do some. But yeah, other than that, as always, we hope it's helpful. We're trying our best here. And if nothing else, just hopefully we give some kind of pointers about where you can find out more information. But that's it for this week. We'll see you next week, guys.